Good morning and welcome. It is Sunday, January 4th, 2026. Can you believe it? This is the first Sunday fun day of the new year. Welcome, everybody. Thank you so much for being here. This is, of course, Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Happy New Year, everybody. Therapist You Know is here. Shy Gal's here. Southern CJB Afton. Who else? Therapist You Know, Becky B, Jerry Michael. Thank you, everyone, so much for being here. Appreciate you all. Proud Grizzly is here. I can't believe it's 2026 already. I know that we say this every single year, but this one really snuck up on me. It's not like I didn't know the new year was coming, but for some reason, by the time I'm starting to write 2026 on the date on checks and wherever else you put the date, it has been surprising me. So 2025 was a wild year. 2026 is going to be even more crazy. I am so glad that we can start this adventure off with all of you. Thank you for being here. If this is your time, 700th time back, welcome back. You're in for a good one. We've got a lot of really great questions to start off the new year. And if this is your first time with us, welcome. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I left there and went into private practice as a criminal defense attorney. We started this channel, Courtroom Confidential, with the idea of presenting to you both sides of the courtroom. And this is a show that we do every Sunday called Sunday Fun Day, where we take your questions that you've left us throughout the week, and we're going to answer them live now for you. Thank you so much, everybody who participated and left a question. I tried to get to as many of them as possible. The answer is no, I can't get to all of them, but I try to make sure that we answer at least every subject matter that you guys have been answering, and I try to spread the love as much as I possibly can. Stay to the end. As always, we have some announcements. There is some changes in our programming coming up this week, so I don't want you guys to miss that, so stick around to the end. But as always, it is Sunday. Annalie Finch kicking us off. Thank you so much for the super chat donation of coffee fund for our awesome mods. Appreciate that, Annalie Finch. K9 Catherine, wow, thank you so much for your generosity. Says, in honor of the beautiful Noreen. That's very kind of you. Proud Grizzly, thank you so much for the super sticker. And Heather Coopersmith, thank you so much for the super sticker. You guys are all fantastic this morning. I appreciate it. Take a deep breath. You've made it. It's Sunday. It's the beginning of a new week or the end of the old one, depending on how you look at it. Hit that like button, subscribe if you haven't already, and share this with anybody that you guys might feel would enjoy it. But let's go ahead and see who's kicking us off this morning with our very first call.
Hi, Josh. This is Jenna from Albany, New York. Happy Sunday Fun Day. I'm just listening to the last question of your last episode about the Lorenz Kraus case. I actually live right in the neighborhood where he and his parents live, and I grew up a couple houses away, so I knew him and his parents when I was a child. I don't know if it's a correction or clarification or just more information for you, but the news anchor, Greg Floyd, did not go after him. Lorenz, once they found his parents' bodies in his backyard, he started shopping around and calling all of the news stations and radio stations and everyone until he got someone who would talk to him and would take his confession. So then Greg Floyd accepted and cooperated with police and all of that and did a great interview. My question is, from what I've seen in the news recently, it looks like they're trying to get his confession thrown out now. I don't know if their argument is just because it wasn't to the police, it was a news anchor, or if they're going to say that he didn't have capacity or what. But how do you think that is going to go for him?
Jenna from Albany, New York. Let's put you on the map. What a great question to start us off with. This is a crazy case. If you guys aren't aware of this one, it wasn't on my radar till somebody actually asked us about it. I think it was last week or the week before. So thank you so much for Jenna to Jenna for reminding us of this one. Yeah. Well, and thank you too for that little bit of clarification. I was not aware of that. Apparently, he was the one that sought out the media attention on this case. But just to catch everybody else up who hasn't been following this one, this is out of the Albany area where Jenna lives. 2 bodies were found in a home, and they were identified as 92-year-old Franz and 83-year-old Teresa Kraus. Interestingly enough, they believe that they had been there for some time, years, in other words, and they had still been collecting Social Security benefits. So that's just another wrinkle in this whole story. Later on, after the discovery of these bodies, their son, Lorenz Kraus, does a 30-minute interview with a CBS affiliate there in Albany called WRGB, and the anchor's name was Greg Floyd. I thought Greg had found him. Turns out Jenna's telling us, no, it was the other way around. He was looking for someone to tell his story to. Well, during this interview, Greg, doing some great reporting, continues to press upon him, and finally, Lorenz comes forward and says, basically that he killed his parents, and he considers it a mercy killing. He says they knew that this was it for them, that they were perishing at your hand. That was a question from Greg. In other words, did they know you were about to kill them? Yes. Answer. And it was so quick. I did my duty to my parents. My concern for their misery was paramount. Well, the law enforcement in that area didn't entirely see it that way. When he went outside, he's immediately picked up, there he is, by police as he's leaving the studio. Now, the question becomes, because of that, and Jenna asks a very interesting question here. I am not surprised, by the way, that his attorneys are going to challenge that quote-unquote confession that he made to the news anchor, Greg Floyd, saying that it was somehow abusive of Miranda. Now, how is it abusive of Miranda? Well, they're saying because the police were essentially there and waiting and in on it, and perhaps even giving Greg a little bit of coaching ahead of time, was Greg somehow an agent of law enforcement, therefore making that a law enforcement interrogation. Whenever we're talking about Miranda, I hope this is one thing, if you guys learn anything that you take away from this channel, is that Miranda has, it's a 2-prong analysis. Custodial interrogation. 1, was he in custody? And 2, was he being interrogated? So let's take a look at the second part of that first, I guess. Was he being interrogated? Well, he was being asked questions. Now, those questions weren't being asked by law enforcement, and usually that's the end of your inquiry. Hey, he's being asked questions by a reporter. It's not a cop. Therefore, Miranda is not at play. Well, what if that reporter, that anchor, is essentially acting as an agent of law enforcement because he's working with law enforcement? That's an interesting question, right? I'm not saying that's what was happening here, but to explore this hypothetical, let's say that's what was happening here. Miranda is still not concerned because Miranda isn't whether or not that person is an agent of the police or even somebody undercover. What if he was an undercover officer saying he was an anchor? Would that create a Miranda issue? No, because a Miranda only applies if the defendant, in other words, Kraus in this case, subjectively believed that he was being interrogated by law enforcement. Isn't that interesting? So when you are in jail and you're in custody clearly, and there's another cellmate in there who's talking to you, and you don't know that that cellmate is in fact an undercover police officer that's just there to try to get some information out of you, Miranda is not at play because you do not subjectively, you're in your own head, believe that that person's a police officer. Miranda is only concerned with the coercive nature of a police interrogation. When you're in custody and you know you're being asked questions by a cop, we feel that that is a situation which creates such a potential for you running your mouth where you might not otherwise, that we feel that you should be advised of your Miranda rights. So an undercover officer posing as a cellmate, an undercover officer posing as a news anchor working on behalf of the police, none of that is a problem. And then you go to the other part of it. Was he in custody? Well, clearly he wasn't. He's sitting here in a studio. He looks like he's free to go. And in fact, he was free to go. It just so happens that when he walked outside, he got arrested by police. So great argument for them to make. I'm not surprised that they're taking that shot. I don't think it's going to go anywhere. But Jenna, that was a great question to kick us off this morning with. Thank you so much. All right, let's keep it rolling here. Who do we got next?
Hello, Josh, Tiffany, and Kaylin, mods, and of course, our sweet chat. This is Pammy in Fort Worth, Texas. I just got to say how much I love this channel. I love everything Josh does. He's just such a sweetheart. But now I want to say thank you for the gift card giveaway. I was so surprised when Therapist emailed me and let me know. And also, I was very pissed that I was not in chat that day, of all days, to not be in there. But I'll survive. I just got through actually making my order online, and I got the PJ pants, the t-shirt that says coffee because murder is wrong, because we have to be told that, right? And also the denim ball cap, because I go to lots of sports balls for my grandkiddos. I probably won't be modeling that and sending a picture in, just saying. Anyway, I love this channel. I love you guys, every single one of you. And I want to wish you all a very happy, healthy, and beautiful new year. Take care, everyone.
Oh, Pammy, I am so glad that you won. Pammy from Fort Worth, Texas. Let's go ahead and put you on the map. We did an end of the year giveaway, and Pammy was one of our winners. She won a gift certificate to our shop. Everything that she just mentioned there is available on the shop, so please go check it out at thecourtroomconfidential.com. We've got hats, we've got t-shirts. I especially love that t-shirt, the coffee because murder is wrong, because it's true. It's a true statement as well. Murder is wrong and coffee is good. But we've got a bunch of fun stuff up there right now, including the PJ pants. So Pammy, I'm very, very happy that you won that. And we do expect to see a couple of pictures from you modeling some of those items, but I'm so glad that you were one of our winners and able to, there you go. Easily distracted by trials, coffee because murder is wrong. Thank you so much, Pammy, for the kind words. Nate, thank you for the super chat. Happy New Year, everyone. Happy New Year right back at you, Nate. Yeah, 2026. Mimi D1, thank you so much for the super chat. Says, love being part of the CC crew. Thank you for this channel. Happy 2026. What a great way to start off the new year. I'm very, very happy. We were saying that I think 2026, as far as if you've got any New Year's resolutions, go ahead and start those on Monday. Thursday was kind of the soft launch of 2026. You don't have to jump into going to the gym or eating healthy and all that. Give it a good try. Maybe substitute the hash browns for some cottage cheese starting on Thursday. By Monday, you can hit the gym, but it's a soft launch until Monday. Proud Grizzly has been a member for 4 months, everybody. Golf Clap says, juiced for Sunday Fun Day. Thank you so much. We're glad that you're here. Southern CJB has been a member for 9 months. 9 months. Yay. Happy Sunday Fun Day, y'all. Well, right back at you, Southern CJB. And Forrest Nelson has been a member for 14 months. It's almost like we're doing toddler ages now. When you start getting into 14 months, 26 months. How old is your daughter? 46 months. Hit that like button so others can come and find us. Thanks, Josh, Tiff, Kaylin, and the super mods. Thank you so much, Forrest Nelson. All right. What a great couple of first calls. Let's keep it rolling here.
Hi, Josh. This is Jerry Michael at Newport News, Virginia, one of your CC learners. My question is regarding Brian Walshe. Did he not testify because he had heard all the evidence from the prosecution and realized that he would be fighting a losing battle. And I'm sure his defense attorney probably too told him after they heard the evidence it would not be wise to testify. What do you think about that? Thank you. You guys have a good Sunday.
Jerry calling from Newport News, Virginia. Let's put you on the map. Thank you so much for the call. Excellent observation, Jerry. Did he intend to testify, talking about Brian Walshe, who murdered his wife, now the convicted killer out of Massachusetts, murdered his wife, chopped up her body, spread her remains all around the Boston area, which has never been recovered, just recently convicted. And there's his wife, Anna Walshe. May she rest in peace. All indications were that he was going to testify, especially given the opening statements given by his attorneys, where they talked about how he discovered her body, how she was suddenly dead, inexplicably, and he panicked. And they gave a bunch of details that only Walshe could testify to. So everybody, I'm sure, including the jurors, expected for him to testify. Well, why didn't he? Well, Jerry's theory is that maybe he heard all of the evidence against him and he thought, there's no way I'm getting on this stand. Could be. My only issue with that is it's not like there was surprise evidence. It's not like the prosecution pulled out some miracle piece of evidence that nobody saw coming. He knew all the evidence against him, and yet he still intended to testify beforehand. I think that you're probably partially right that he got cold feet. I also think he's a coward and maybe thought, well, I'm going down anyways. I don't want to go through brutal cross-examination and further embarrass myself in front of the entire country. I don't know. I know that the people who are probably most shocked are those two folks standing right next to him in that photograph, his attorneys, who really got hung out to dry. If anybody's going to be most upset with him, I know the judge was upset. The jurors were probably upset. I think it's his attorneys that were probably most upset because they formed their entire defense around the idea that he was going to testify and kind of tie everything up in a neat bow. And then he decided not to do that. I don't think it would have changed the outcome. And I think you're probably right, Jerry. He probably just, maybe he was talked a big game before trial, but wussed out, according to Afton. I think he absolutely wussed out. Thank you so much, Jerry, for Newport News, though, for presenting us with that theory. Maybe we will never know. Best Nancy, thank you so much for the Courtroom Confidential memberships gift. I hope everybody enjoys those. Kathy Mamba Bear has been a member for 11 months. Golf clap, everybody. Happy Sunday Fun Day. Happy Sunday Fun Day crew, day crew. I don't know why I'm missing words here. Hey to everyone. I missed tagging. LOL. Love you all. Right back at you, Kathy. All right. Where are we off to next?
Happy New Year, Josh and the crew. This is Valerie calling from Valparaiso, Indiana. I have 2 questions, but the second one I'll probably have to do a second recording for because this is going to be long. This is about OJ. After you're going through this on Sunday, I realized that perhaps I could finally get this question answered. No one has ever been able to answer this for me. 1, the prosecution had said that OJ had driven the Bronco from the crime scene and parked weird and dripped blood up the driveway into the house. But the prosecution also said that OJ jumped the fence, banging on Cato's wall and dropping the glove behind the guest house. So which is it, since both things could not have actually happened? I actually watched almost every minute of every day of the live feed, and you're absolutely dead on about Barry Scheck, from pointing out that the bindles were still wet when they arrived places weeks later, and there was more DNA on a sample collected on a gate days, if not weeks after the crime, but there was more DNA in that sample than there was on the rest of the. Hi guys, Valerie in Valparaiso, Indiana. Second question, it's about Brian Walshe. They tell us that intent can be formed in an instant. It doesn't have to be days or weeks or even hours before. So why are you so surprised that he got murder one? And you had said that, you would have expected him to have made Google searches about killing someone, not just about cleaning up a body. But if he, in the midst of a fight, strangled her, which wouldn't have left any blood anywhere, and then had to figure out what he was going to do next, his intent to kill her could have started before his hands were around her throat, in my opinion. So your thoughts on that? Happy New Year, everybody. Thanks again. Bye.
Valerie from Valparaiso, Indiana, let's put you on the map. A couple of really great questions. I'm going to answer the second one first. So this is a concept that is not the easiest to understand. Even a lot of attorneys still struggle with this whole thing, but you're absolutely right, Valerie. Intent can be formed within a moment. And so Valerie's question was, well, if intent can be formed within a moment, why am I shocked that he got first-degree murder? I mean, shocked is probably a strong word. I would have expected second-degree murder. I think first-degree murder was a little bit of a stretch. I'm not saying that I doubt or are questioning the jurors' verdict in this case. I think that they did an admirable job and considered all the evidence, and I think there was evidence of some premeditation here. But that is the pivotal difference is, yes, intent can be formed in a moment, but can premeditation be formed in a moment? And that's the difference when you're talking about second degree to first degree murder. All murder, and the best way to think about this is all murder starts with second degree murder. Second degree murder is your run-of-the-mill garden variety or malice aforethought murder. Right? Murder that you have intended to kill. And the intent to kill can be formed within a moment. I've used the, Valerie uses the idea of could he have formed that intent with his hands wrapped around her neck? Yes, he could. In those moments, you can go from, I just can't stand you to I'm going to kill you. Sure. I always use the example of you're going up to a traffic light and as you're approaching it, it goes from green to yellow. You make a decision in those moments. Am I going to pound on the gas or am I going to step on the brakes? And that can take a moment, but you've made a decision. You have, with intent, either press the accelerator or press the brake. But premeditation is something different. Premeditation is what aggravates, an aggravating factor from second degree to first degree murder. Sometimes it's other things, depending on the jurisdiction. Every jurisdiction, by the way, defines this differently. They call it aggravated murder. They call it first degree murder. But what makes it something more? What is more thoughtfulness, premeditation, deliberation, reflection? Can that be formed in an instant? Well, that's where things become a little bit more debatable. And that's where I think that when you're talking about the burden always being upon the prosecution, I think the prosecution needs to show that. They need to show some planning, some deliberation, some reflection, something with specific intent, something that was not just formed in a moment, but something that took a little bit of planning. And my question was, did they show that in this case? Now, some people have pointed to the idea that he lied about the location of his phone or that he was searching for the name of his wife's lover. Yeah, I think those might be, and maybe that's what the jurors pointed towards. In my view, this looked much more like a second degree murder case, but none of that really matters now. We're just kind of arguing about things, Monday morning quarterbacking this whole thing. But that is, I think, something I constantly kind of want to drive home. Malice aforethought is the umbrella concept. Second degree murder is a general intent crime. Malice aforethought, intent to kill. Premeditation is something specific intent It's a little bit more. It involves deliberation, reflection, and that's what turns a second-degree murder into a first-degree murder, and sometimes some other bells and whistles. All right, let's get to the, I hope that clears things up. Let's get to the OJ question here, though. This is a great question, too. I don't care how old this case is. I still love talking about this case because there's so many fascinating aspects to this whole thing. But your question, if I understood it correctly, was, what's the deal with the prosecution's theory? If he drove up in the Bronco and he haphazardly got out, how did he also do that and then still come around by the side, by the back gate, over the fence, bump into the guest house? I think both things are true. In other words, the one thing that I will take issue with when you were describing that is I don't believe any blood was ever recovered on the driveway of the Rockingham house, of where OJ actually lived, okay? There was blood recovered from the walkway and driveway of the Bundy house where the murders took place. So in other words, they have OJ's blood and obviously victim blood at the Bundy scene, going from where the stabbings took place along the walkway from where her condo was to the back alleyway where they believe he fled from, and on the gate leading out to the driveway in the back alleyway. Then they have OJ and victim's blood inside of the Bronco. The Bronco, they then believe he drove from Bundy to Rockingham, parked it haphazardly. In other words, parked it as if someone who was in a hurry would park it, but then didn't go in through the front gate into his house, but went around either the side or the back. I should have pulled up a map of this, to where he could have hopped the fence to come in so as not to be seen going through the front entrance. That is their theory, okay? Their theory is that he didn't want to be seen by anyone going in to the front of the house because he wasn't supposed to be there, right? He's supposed to be inside of his house getting ready to go to Chicago the whole time. So instead, he comes over the back fence. In doing that, they believe that he bumped into a air conditioning unit on the outside of the guest house where Kato Kalin was living. Kato Kalin, who's my new best friend, by the way, I just happen to have been on a podcast with him. Kato describes to police that he hears a loud thumping. He even says that he thought it might have been an earthquake when police arrived to the Rockingham residence, because they find Nicole and Ron Goldman. They realize that who Nicole is, and they realize her husband, next of kin, OJ Simpson, lives just up the street. So they respond to the Rockingham residence. They speak to Kato Kalin. Kato Kalin says, hey, I heard thumping outside of my wall here. Mark Furman, goes around the side and finds the bloody glove in the area where somebody could have been walking in that kind of that little pathway to the side of the guest house. The glove matches the glove found at Bundy. Okay. They both have victim and OJ blood on them. Where they also found blood was on socks inside of his bedroom, where they believe he got inside, quickly undressed. His socks had blood on them. They also had Nicole Brown Simpson's blood on them. So those are the locations where they believe they found blood. But I don't believe there was ever, and if I'm wrong here, I'm sure somebody's going to tell me, there was blood leading from the Bronco through the front entrance to Rockingham. There was some blood in the foyer, but not blood leading up to it, because they don't believe he went through the front, through the driveway. They believe that he went around back. I hope that makes sense. The theory being OJ kills Ron and Nicole. He quickly gets into his Bronco, drives back to Rockingham, parks it haphazardly, goes around back, bumps into the air conditioner, drops the other glove. He had left one glove already back at the murder scene, gets back into his house, undresses, quickly redresses, and then gets into a waiting limousine to take him to the airport in Chicago. And there's the link to the interview that I did with Cato and Zenner. So please check that out. Thank you so much for that, Afton. All right. Hope I cleared that up. If that causes any controversy amongst any of you, I welcome all the comments. All right. Kouri Skim, thank you so much for the super chat. Says, so grateful to have found this channel. I love learning from you and even my Bigfoot believing reality TV watching husband looks forward to your show weekly now. Thanks for that 2-hour reprieve weekly. Well, hello to hubby, and thank you so much. I appreciate that. Oh, that makes me feel good. Converting skeptical husbands one husband at a time. And Nate, thank you so much for gifting the membership. Appreciate you, Nate. She Wolf, thank you for the super chat. Says, happy New Year, all of CC. Thank you so much. Jenny G214 has been a member for 9 months, everybody. 9 months already. Love this channel. Thanks for all your hard work, Josh, Tiffany, Kaylin, and Mods. Well, thank you so much, Jenny, for being here and for all your support. All right. I'm already exhausted. Let's keep it rolling here.
Hi, Josh. This is Monica from Omaha. Happy New Year. As the Luigi Mangione case has more hearings, he will be tried in federal court. Am I correct? And I guess I don't have a question so much as a statement. I'm really concerned about jury nullification with this guy. Even my nephew on Christmas was waving the Mangione flag. I could hardly believe it, but he has so many supporters. With all this evidence and the video, I worry about jury nullification. Have a great Sunday, CC. Thanks for taking my question.
Monica from Omaha, Nebraska. Let's put you on the map. Thank you so much for calling in. Try to be a little patient with your nephew. I'm sorry. I will say this. Yes, it does appear as though Luigi Mangione has a lot of support, but I think that's the appearance. I think more than anything, it's just a very vocal minority of people who feel very strongly about it, show up, wave a bunch of signs, but I don't think that is a reflection of the larger community. Even in New York, even where he's going to be tried, I don't think you're going to have a hard time finding unbiased jurors. My experience, I've worked on a few, I've been blessed and privileged to work on a few high profile cases. And we walk in there and we always think, oh my God, how in the world are we going to find jurors who have not heard about this case? This case is so big, so important. Everybody's talking about it. How are we going to possibly find jurors who are not biased about this case? And then you get a bunch of people who come in and are like, I don't know any of these people you're talking about. I don't know the defendant. I don't know the victim. I don't know who you are. I don't know what I'm doing here. I just want to go home. They're concerned about their kids' little league. They're concerned about the Kardashians. They're concerned about the price of eggs. They're not concerned about these legal issues and who got arrested and what they're charged with. It's just not their thing. Some people, you and I and all of us, take a lot of interest in it, but there's a lot of people who just don't care about this stuff. I bet you right now, if we did a straw poll and just started walking down the streets of Manhattan, asking people, what do they think about Luigi Mangione? You'd be shocked by how many people go, I have no idea who you're talking about. But yes, he does have a lot of very vocal supporters who happen to be towards the younger side, who like to, think of him as this kind of folk hero. I think that's tragic. I think it's awful. I think he's a murderer. I think he's a man who murdered a father and a husband and father of children just because of who the man, what occupation he happened to have. He didn't matter to him. He didn't do anything personally to Luigi Mangione. All that mattered is he carried the title of CEO of a healthcare company. He could have picked another healthcare company. He could have picked another executive. He didn't care. He wanted to make an example, be a folk hero, and this man lost his life. And A wife lost her husband and children lost their father. And I think that's tragic that anybody would go out there and celebrate this. And I hate when people talk about this and they go, yo, no one should ever be killed, but there should never be a but at the end of that sentence. No one should ever be killed. Anyhow, so to your concern, first of all, let me answer your question about will he be tried federally? The answer is he's been charged both on the state level and federal level. He's actually been charged on the state level by more than one state. Pennsylvania's got some charges against him, but really the controlling jurisdictions here are New York State, which has charged him with now second-degree murder. He was looking at first degree, but the judge dismissed the terrorism allegation. So now it's just second-degree murder and some weapons allegations. And on the federal level, he's looking at interstate stalking, which is how they're gaining their federal jurisdiction. First-degree murder, use of a firearm. He's looking at the death penalty, weapons violations, everything else. What is happening is the feds are allowing the state case to play out first. So after he is tried for the state case, win, lose, or draw, the feds are going to have their turn. And it'll be interesting to see what happens. If he's convicted and sentenced on the state case, I'm curious if the feds will still go after him. I think they will, though. I think they're interested in prosecuting this for a number of different reasons. It will be interesting to see if they continue to pursue the death penalty. Just because they're talking about it now doesn't mean they have to continue to. But we'll see what happens. But the idea is, yes, he will, right, as if nothing changes, he will have both a state and federal trial. And as far as jury nullification goes, yes, it's probably more of a concern in this case than in most cases. If I were the prosecutors, I would be wanting to make sure that my voir dire was extensive. I would want to ask the judge for, questionnaires and more time to question people so that you don't get some sort of undercover rogue juror on there who's just looking to, make a statement. But like I said, I think that even in these high-profile cases, you'd be surprised at how many people you can get on there that really haven't made up their minds about this or haven't even heard about it. So, like I said, give your nephew a break. He doesn't quite know exactly what he's supporting, I hope. Anyhow, thank you so much, Monica from Omaha. IGG rocks. You're the best. IGG does rock. Chick-fil-A chicken noodle soup fun for Josh. Oh, I didn't even know Chick-fil-A makes a chicken noodle soup. Now I do want that. Thank you for that. I appreciate that. I am a little under the weather. I'm sorry for that, guys. We just got little ones. We've been living with little ones at home on their Christmas break, and they, like to cough all over Dad's face. Kristen Perry has been a member for 2 months. Says the best channel. Well, thank you so much, Kristen Perry, and thank you so much for being a member for 2 months. All right, let's keep it rolling here.
Hello, Josh. Hello, Courtroom Confidential crew. This is Becky E. from Des Moines, Washington, and I called last week, actually, and my thing was played yesterday. I forgot to give you my YouTube name. I am Don's Mom 725. Anyway, thank you for answering my question on the Nick Reiner NGI question that I had. My question for today, I'm sitting here listening to your Monday podcast, and you just were talking about the Kouri Richins case. And what I'm wondering is, will the walk the dog letter be able to be brought into evidence? I'm hoping so, because I was thinking back to the Donna Adelson case, and they were able to bring in, I can't remember her name now, but her cellmate that, wrote the stuff in the journal with her. And so I'm hoping that that'll be able to be brought in. I don't think she has a shot of getting away with this. Even if the the gal or the two that are sketchy witnesses, aren't reliable. I just think that, I don't know, she did this. So anyway, I'm curious if that'll be able to come in to the trial. So anyway, thank you very much, and I'll look forward to hearing what you have to say. Take care.
Becky from Des Moines, Washington. Good to hear from you. Let's put you back on the map here. Des Moines, Washington. asking about the Kouri Richins case. That is scheduled to start this year. I think it made our top 10 of cases to expect in 2026. So please check that video out. I'll be talking about that more later. A lot of really positive feedback from all of you for watching that one. This one has been dragging on for quite a while. She's accused of murdering her husband by overdosing him with fentanyl 5 times the lethal dose in his Moscow Mule. Oh, all because of money, it sounds like. Well, story goes, after she got arrested, she's in jail. She's awaiting trial. She's been in custody all this time. She wrote a letter to ostensibly to her mother. And here it is. It's been called the Walk the Dog letter because at the very top of page number 1, in big capital letters, it says walk the dog. And prosecutors believe this was kind of her attempt to throw people off because there's a kind of a gray area. There's what's the word I'm looking for? There's an area where in custody defendants can kind of exploit the system a little bit because they are allowed to have a certain degree of privacy in their communications, right? Law enforcement is not supposed to rifle through all of their correspondence because some of that could be going to their attorneys. And they are supposed to stop reading letters that appear to be correspondence between a in-custody defendant and their attorney. And that's kind of the issue at play here. So they're wondering if she wrote walk the dog on the top of this to kind of throw investigators off the scent that they shouldn't read the rest of this letter, because then the rest of the letter appears to be, according to prosecutors, coaching people on how they should testify and things that she needs people to say in order to establish her theory of her defense that essentially her husband, Eric, overdosed because he was a drug addict and he was buying a bunch of drugs from nefarious characters, and therefore she had nothing to do with his death. So this letter, because it is highly, could be potentially prejudicial to her case, they've litigated this quite a bit. And the two main arguments that her attorneys are trying to make are, one, this is attorney-client privileged, and two, this is attorney work product. And we'll talk how those both might work and whether or not they will work. Attorney-client privilege protects any communication between a defendant and their lawyer. But how is that waived, or how is that privilege pierced? Well, the first way that you do it is by involving a person who's not your lawyer. So if this letter is addressed to her mother and she's talking to her mother, that obviously affects the idea whether or not this is a attorney-client privilege, and it can be viewed as waiving that privilege, even if she was trying to communicate with her lawyer in part by including her mother in the conversation. She waives that privilege. When I meet with potential clients and they bring along family members, I always ask if the family members can kindly step outside while we have a private conversation so that we can protect that attorney-client privilege if it becomes necessary. They're also saying, the prosecution, that this was waived because Kouri's previous attorney, Sky Lazaro, kind of published this letter herself, talking about it and talking about how, trying to argue how it's not witness intimidation or witness coercion, that it's something else entirely. And anyhow, they're saying it's a moot point as far as attorney-client privilege goes. And I think that argument probably will prevail with the judge based almost solely on the idea that the letter was addressed to her mother and not her lawyer. But what about attorney work product? This is any document, item, thing prepared by a lawyer or client in anticipation of trial, which is interesting. Some people might not appreciate that. But defendants can participate in creating attorney work product. In other words, we want to protect attorneys' ability to prepare for trial, which might include writing down their mental impressions, their theories, their strategies, jotting down witness statements, doing their own research, and that could include participation from their client as well. So it's anything prepared for in anticipation of litigation by the attorney or sometimes the client. Could that have been the case here with this letter? I guess there's maybe a stronger argument for that if she's discussing thoughts, impressions, theories, strategies with her mother that she has discussed with her attorney. Is this all kind of wrapped up in attorney work product? Again, maybe a better argument, but I still don't think a winning argument. And I think that the judge will allow this in. Interestingly, though, Judge Richard Mrazek has not ruled on this that I'm aware of. If you guys know about this, I did some research and I don't think he's ruled on this letter just yet, which will be interesting because I think this letter, I always feel that the conduct of a defendant since they've been arrested is sometimes more powerful evidence than things they did before their arrest, because a lot of jurors say, what would I do as an innocent person accused of a crime? Would I try to get people to testify a certain way? Probably not. Probably the consciousness of a guilty mind. Anyhow, thank you so much for that, Becky, from Des Moines, Washington. Great question. Joy W. Can, thank you so much for supporting the mods with coffee. Appreciate that. Anonymous keeps on coming back with supporting the mods with coffees. I appreciate that. How long has Anonymous been a member, by the way? Thank you for supporting the mods. Appreciate that. Nate with the super chat and a question. Josh, what do you think about the Venezuela president being arrested? Wild stuff. I will tell you the part that is most shocking to me is I think they said the entire operation took less than 3 hours or something, which is just remarkable. The skill and might of the U.S. military that they can run in there 3 hours later, have somebody arrested, and didn't lose one life or vehicle along the way. Cheryl, R4811, thank you so much for gifting the membership. Appreciate you, Cheryl. And IGG rocks for the super chat. Tiff Ritter, grab something for yourself too. You're a rock star. Oh, there you go, Tiff. You can have some of my soup. And thank you, Cheryl, for the membership. All right. Where are we at here? Hold on. Okay. Here we go. Moving on.
Hi, Josh and crew. Wishing you all a happy new year. So this is Misbehaving, and I'm going to say this week I'm from Aberdare, which is spelled Aberdare, which is in South Wales, as Wales need a bit more love on the map. So my question is, we all know what a grand jury is used to decide if there's sufficient evidence for an indictment to go ahead. Now, I've read that there's an investigative grand jury looking into David for the death of Celeste Rivers. So can you tell me, is there actually a difference between the two grand juries? And if so, what powers the investigative grand jury has that a normal grand jury may not? Thank you very much. Bye-bye. Love you all.
Misbehaving from Aberdare, Wales. And thank you for spelling that out for me. There, we're going to put it on the map. Let me see. Can we zoom in there? I want to get my UK geography down. There we go. Thank you so much for that, Ms. Behaven. Great question too. We get a lot of questions about grand juries. For some reason, this is something that a lot of people are curious about. Like, what are they? How do they work? I know that they're kind of unique to the US in the way that they're used. And so I'm happy to answer them, but it does seem like every once in a while we get another question about the grand jury. So this one is about David and the murder. I'm calling it murder, though they've not officially classified it as a murder, but certainly the death of Celeste Rivas. And the latest that we heard is that an investigative grand jury has been convened. The DA who's in charge of that is a woman by the name of Beth Silverman. She's a very experienced prosecutor in the DA's office. She's in the major crimes unit. She's been there for close to a couple decades, I think now. One of their top prosecutors. So this case is certainly in very capable hands. She's also not shy. So if she feels that there's enough evidence to charge somebody with a crime, she's going to charge somebody with a crime. But what does that mean about it being that it's investigative? Does that mean, he's not going to get indicted, or how does all of that work? So a grand jury, how do I explain this best? We're used to trial juries, or they're even sometimes referred to in the law, or they used to be referred to as petite juries, because they're not the grand big jury. It's 12 people, as opposed to sometimes it could be as many as 30 when you're talking about a grand jury. Those juries serve a very specific purpose. A trial jury serves the purpose of deciding guilt. Is the case presented? Have the prosecution proven that beyond a reasonable doubt? That's a very specific question. They sit only for one trial to answer that one very specific question, and then they're released. A grand jury is a larger group of people, and they can serve different purposes, and they also don't just serve to answer a question on one case. They can consider many different cases. So they serve for a period of time. It can sometimes be for 30 days. It can be for 6 months. If you're serving on a grand jury, that means that your service is going to last for a longer period of time, and you're going to hear all sorts of different cases. And you might even be asked to do different things. Sometimes you are being asked to indict a person. You are being given evidence presented to you in the form of documents, witness statements, testimony in front of you, and the prosecution may ask you to decide the question of, is there enough probable cause, not beyond a reasonable doubt, but probable cause to believe that a crime has been committed by the person that they're alleging committed that crime. And if you believe so, then you hand down an indictment. That is, in California at least, done rarely. Usually in California, an indictment comes through, or a charging document comes through a criminal complaint, which doesn't go through a grand jury. But it's used in cases where they're especially large. If you've got several different defendants, and going through a prelim might take months. So instead you indict everybody through a grand jury, especially complex cases for the same reason. High profile cases, many times they'll go through the grand jury if it's a very, very high profile case, because they don't want the media attention during a prelim. They also don't want, because grand juries can be convened in secret, they might not want people knowing that somebody's under investigation. There have been people who have been under grand jury investigation that you don't even know about, and they don't even know about, because all of this is secret. Because the other thing they can do with the grand jury is not ask for an indictment. They can just use the grand jury for investigative purposes, because when you convene a grand jury, what it does is it gives you the power of subpoena. When you have a grand jury convened, you have the authority, which doesn't exist before then, to have police go out and serve a subpoena on someone, and you have jurisdiction over them for the court to order them to come into court to testify, which you cannot do just as police investigating a case. If police are just investigating something without grand jury subpoena power, they can't force anybody to talk, and they can't force anybody to come in to testify. You convene a grand jury, you get subpoena power, you can force those people to come into court, and you can force them to testify under threat of contempt. And sometimes they'll do that just to get people on the record. Maybe they don't know if they have enough for an indictment. And perhaps that is what's the case here with the David case. Maybe they don't know if they have enough for indictment, but they need to get some people on the record to figure out if they do. And so they call it an investigative grand jury. Now, the question becomes, just because it's investigative, does that mean that they can't indict someone? Well, the difference between an investigative grand jury and an indicting grand jury is really up to the prosecution and what they're asking them to do. So it's not like you get a separate, different group of people. It's the same people. It's just, are you only asking for them to listen to this testimony, put it on the record, or are you eventually going to ask them to return an indictment? And just because they're asking them to investigate doesn't mean later on they can't ask for an indictment. I feel like I've made that confusing. I hope that I've made it more understandable. I think your next question, if I'm hearing you, might be, well, if this is all secret, why do we know it's happening? And why are we being told it's an investigative grand jury? That's a great question. I think a little bit of this is PR on the part of the police and the prosecution. They know the public is sitting out there going, what the heck is going on with this case? Why has nobody been arrested? So they leak the idea that a grand jury has been convened. That is something they didn't have to disclose. They let people know that a grand jury is being convened, but they let them know it's an investigative grand jury. So maybe people don't get all wound up when an indictment doesn't come quickly, but at least they know they're doing something. That, to me, is kind of my way of reading through the lines, deciphering the tea leaves here. I think there was a little bit of PR taking place with actually disclosing the idea that a grand jury, an investigative grand jury, has been convened in this case. Doesn't mean an indictment isn't coming, but I think it was just kind of to calm everyone down. Anyhow, great question. Misbehaving from Aberdare, Wales. All right. June. You told me how to say this right. June Sidlauskas. I think I said that right. Thank you so much for supporting Mobs with Coffee. Always appreciate you, June. All right. Let's keep it rolling. Don't look at me. I'm pressing all the buttons.
Hi, Josh. This is Pam from Michigan. I just listened to your Monday night episode on the 10 trials, and I don't know if it's a question about the Shanna Gardner trial, but the whole thing hurts my head to think about. I'm not really sure why they're doing two separate juries, one trial with both defendants. Whenever I watched the pre-trial hearings, Jose Baez just really muddies the water a whole lot for me. And I feel as if I was a juror, I would be so confused. I hope justice is served here. I believe she and her husband at the time, if they're still married, are guilty. I believe she planned it. I do truly believe, just from her history and watching and seeing some of the evidence. But I just am really concerned over whether everything will get through, if the two jurors will get things confused. I don't know how to think of this other than I hope that justice is served, and I hope that they do find her and her husband guilty of planning this whole murder of Jared Bridegan. I think the whole thing is very sad, but again, it's such a confusing story. So anyway, can't wait to hear what you think about my question and look forward to Sunday Fun.
Pam from Michigan. Let's put you on the map. Thank you so much for calling in. Always appreciate hearing from you. It is confusing, the Shanna Gardner case and the Mario Fernandez case for the murder of Jared Bridegan. And we talked about this When did we talk about this? I don't know. It was recently where we were talking about dual juries and why would they need it. I think I was on somebody else's channel talking about this and the idea of dual juries and why that would become necessary when you're dealing with two defendants, and how does that all work? And I tried to explain it, and I probably did a very poor job of doing it. And so when I heard this question, I realized maybe this is above my pay grade and I needed to bring in some big guns. And so a good thing that I always have available to me is I can always phone a friend.
Hey, Josh, thanks for reaching out. For those who don't know me, my name is Scott Reisch. I have the podcast Crime Talk with Scott Reisch. Pam, that is a great question. Why would there be two juries impaneled for two defendants charged with the same crime? For example, in the Shanna Gardner, Mario Fernandez trial. This answer is simple. In a United States Supreme Court case back in 1968, the Supreme Court said you can't have a joint trial with two co-defendants where some evidence is admissible as to one defendant, but inadmissible as it relates to the other. Normally, they would just conduct two trials. But for efficiency purposes, two jury panels will be in place. One jury will hear the evidence as it relates to, for example, Shanna Gardner. One will hear the evidence as it relates to Mario Fernandez. If there is inadmissible evidence, say, for example, as it relates to Mario Fernandez, that jury will be excused or they will be instructed that they cannot consider that evidence in any way. It is a way to have judicial economy by having one trial versus two, right? Can you imagine a lengthy trial and you have to do it twice, three times, something along those lines? So that's why they impanel separate jurors for different defendants in the same case charged with the same offense. I hope that answers your question.
Thank you so much, Scott Reisch from Crime Talk. I think he did an excellent job of explaining that. It really does come down to what we call judicial economy. Because the only other way of solving this problem would be to have two entirely separate trials. And that would just take forever. I mean, this trial is going to take forever as it is. So let's save a little time. We'll impanel two juries. And when an issue comes up where only one jury can consider the evidence, we'll remove the other jury. So sometimes you got them sitting in the back room. They put on some evidence. Then they bring both jurors out. I've done this before in cases, and it usually comes down to maybe one witness. So it's not like they're in and out, back and forth. It usually comes down to one witness says something that can only be used against one of the defendants and not the other. What is that, Ritter? What could possibly only be used against one defendant and not the other? Well, usually it has to do with statements made by one of the defendants. We all know that anything a defendant says can be used by the prosecution as a hearsay exception under the party opponent admission rule. So even though an out-of-court statement made by either one of these two would normally be considered hearsay, because they're the defendant, it's considered a party opponent admission and it's coming in. Well, what if Shanna Gardner told her friend, okay, Mario and I paid to have Jared killed. Let's say that's a statement that she made to a friend. Mario and I paid to have Jared killed. If this was only a trial against Shanna, you just call that witness and have them give that statement, and the hearsay exception would apply, and the jurors can consider that. But now you got Mario sitting there. And Mario goes, well, that's not a statement I made. That's a statement she made. So that hearsay exception only applies to her, not to me. And if you're going to use that statement, it's hearsay, and you have to put the person who made the statement on the stand, and that's Shanna. And you can't make Shanna take the stand. So now what are you going to do about me? So what they do is they have Mario's jury go sit in the back, and they don't get to hear this statement. That it doesn't get to be used against Mario. It only gets to be used against Shanna. That's how it works. That's why you have two juries. That's why you preserve everybody's constitutional rights and you still don't make this drag on to 2 different trials. I hope that clears things up. It's a process that's not used all that often, but in multiple defendant cases, you're going to see it. I've seen, in fact, though I've never done it, I've seen where they've had 3 juries in a single courtroom just to try to save some time. Really complex, kind of next level 3D chess sort of prosecution stuff, but it does happen. So anyhow, thank you so much, Pam from Michigan. Court Dog Daniel says Sunday fun day better than football. Don't know about that. Certainly not playoff football, but Daniel, I appreciate your kind words. The crafty RN has been a member for 4 months. Golf clap, everybody. She's guilty, in my opinion, from Jacksonville. Well, there you go. And Angela D. Robbins, has been a member for 6 months. Says, love my CC crew and Grizzly family. So thankful for all of you and wishing you all a happy and prosperous new year. Right back at you, Angela. Appreciate the kind words. All right. We having fun? Is this a good way to kick off the new year? I think so. What did I do here? I hope I got it all right. All right, let's keep it rolling. Wait, hold on.
Hey, Josh, Beth Mods, and everyone else at Courtroom Confidential. First of all, Happy New Year. This is Annie Kay calling from Santa Barbara, and I wanted to ask a question about the Aaron Spencer case. Would it have made a difference if the confrontation had happened within their home and prevented this kind of kidnapping from happening, alleged? And would that have made a difference? Secondly, is this a political statement about vigilante justice? And thirdly, most people understand that when a child is taken, their survival rate within the first hour or 2 is key and crucial. And would that make any difference in this case in terms of a trial? This whole thing seems like a travesty to me, and it's really upsetting. I know a lot of people feel the same way, but I would love your answer on the in-house question. Thank you very much for all you do. Bye.
Annie K from Santa Barbara, California. Let's put you on the map. Thank you so much for calling in. Always love hearing from you, Annie. And a great question about a great case, a case that a lot of us are concerned with. Aaron Spencer, it's starting here this month, right? I think we're going to be following that one as much as we can on our sister channel, Courtroom Confidential live trials. So stay tuned for updates on that. Yeah, a prosecution I never thought should happen. It's going to either make me question or lose faith a little bit in the prosecutors in Arkansas, unless I hear more about this. And there are some details which I will say are problematic for Aaron Spencer, but still not enough for me to believe that this man should be prosecuted for murder. And that's what they're doing. They're prosecuting him for murder. They're trying to put him in prison for the rest of his life because he basically saved his daughter's life. Like I said, I would be more concerned with whether or not we give this man a key to the city and have an annual parade in his honor, not whether or not we're prosecuting him and putting him in prison. But Annie wants to know, would any of this had changed if this had all taken place in his home? And I think absolutely it would be a far better case for self-defense if this had taken place in his home, even in states where they don't have the quote unquote castle doctrine, which is this idea that, you know, kind of the normal rules of self-defense and any kind of duty to retreat do not apply inside someone's own house. Even if that is in a castle doctrine jurisdiction, the reasonableness factor of defending yourself and your loved ones inside of your own home kind of goes through the roof. When we're talking about self-defense, it always comes down to a question of reasonableness. Is it reasonable that Aaron Spencer perceived there to be an imminent threat to his or his daughter's life in this situation? Was that reasonable? Arguably, I think very reasonable. was it reasonable in his belief to use deadly force? Again, very strong argument for that being reasonable. His daughter's life is being threatened by a guy who's already assaulted her previous to this, allegedly. He's not letting her go. I mean, it really comes down to kind of a very fact-specific analysis. If we're going with Aaron's version of events, he's saying that the guy's not letting her go, and then the guy lunges at him. All of that gives, I think, a very reasonable belief in the use of deadly force. And then, was he reasonable in his use of deadly force? And this is where things probably become the most difficult for Aaron Spencer, though I don't think insurmountable. But the allegations are that he fired off, I think, 13 shots. That's unloading your gun. Now, you could say, well, that's overkill, and that's an unreasonable use of deadly force. You could also say, if you're going to fire a gun, you unload your gun, and that's just the way that you use a gun, and which is a way a lot of people are trained. So it all comes down to the idea of reasonableness. So is it understanding all of that and applying all of those factors, would it have been even more reasonable for him to use deadly force to defend his daughter inside of his own home? To your question, Annie K, I think absolutely. But is this case political? I think was another one of your questions. Maybe that would explain it. I still don't understand it. I don't understand if there's any kind of history between Aaron Spencer and that local community and law enforcement. I don't know. I just don't get it. And I have not heard an explanation coming from the prosecution just yet that really explains this to me. Now, that all being said, I'm fully of the belief that vigilantism is wrong and you don't take the law into your own hands, and that even a horrible person can be murdered. Totally understand. But even going through the elements as we've explained them, this isn't like Aaron Spencer heard about what Michael Fossler did to his daughter, found him on a street corner one day minding his own business, and put a bullet in his head. This is the guy was actively involved in a crime. He was actively involved in a crime. He was actively involved in the crime of kidnapping. If there is not a greater threat to safety of others in the crime of kidnapping of his own daughter, I can't imagine there being. I don't get it. I do not get it. But thank you, Annie K, for bringing this case up. Anytime I have an opportunity to look at Aaron and his turkeys, it's a happy day for me. So thank you, Annie K from Santa Barbara, for asking the question. All right. Let's keep it rolling here. Where are we landing next?
Hi, Joshua and everybody at Courtroom Confidential. This is Jim. I'm calling from the Marshall Islands. I'm sure I'm your first caller from the Central Pacific. I have two questions that really frustrate me about watching trials online. I love watching them, but there's two things I cannot understand. One is, why can't we just stipulate 60% of what happens? 60, 70% of what's asked, there's no objection to. Why do we have to go through 20 minutes of, so what is your name? Do you know the defendant? Are you married to the defendant? How many kids do you have? Why can't we just pass all of that up? The lawyers just stipulate, okay, I cannot understand this. Why we have to go through this? And so where did you go to school? And then what did you then? And what did you do then? And what did you do then? I don't understand it. The other thing is, why can't a prosecutor take, for instance, the Georgia Kappelman and the prosecutor against Nicholas Casotis? And why can't they just say, do you actually expect the jury to believe this ridiculous story?
Jim, one of my dudes, putting the Marshall Islands on the map. I love that. Zoom out for us a second there, Kaylin. I want to see where the heck in the middle of the Pacific are the Marshall Islands. Look at that. We are just covering the world. All right, I'm calling you out, Antarctica. I don't think we've got anybody I don't think a penguin has called in. Look at that. See? Yeah. Yeah, we got some definite holes on the map here we got to work with. But so far, Jim with a big call from the Marshall Islands. Appreciate that. And one of my dudes too. Great question, Jim. Something I don't even think about, but I love this question. A lot of people in the chat are feeling you on this one too. Why can't they stipulate to most of this? I mean, the answer is, I guess in its simplest terms, is you're right. A lot of 60%, maybe more of a trial is not in contention. It usually only comes down to a few points. So why can't they stipulate to all of that? I think because, well, one, the jury has to learn it, right? And so you can't just say, hey, jurors, I'm about to read to you a stipulated version of things. Just pay attention. I just think that we feel that is not, it may be a faster way of having trials, but it's not a better way. That jurors need to hear the story played out for them. There's a little bit of theater, I suppose, involved in the whole thing. And they need to hear who people are, their relationship to the defendant, how long they've known them, kind of background information, laying the basis for who this witness is, what role they play in this whole thing. And yeah, sometimes it becomes a little tiresome. Sometimes it becomes a little elementary, especially when you get experts and, can you please explain to us what exactly is DNA and what is a chromosome? I think part of that too is attorneys trying to not take for granted what jurors do and don't understand. Many of the people watching and listening right now, like I say, where it's the smartest chat on YouTube, are much more savvy and experienced when it comes to a lot of these legal issues that your typical juror simply isn't. They might not know what DNA is exactly. They've heard it, but don't exactly quite understand it. So I think a lot of that is what's at play too. And I think a final reason is you've got to make a record of this stuff because a lot of this gets appealed. And can you imagine what the appeals might be if somehow your stipulation wasn't inclusive of every final, granular point that needed to be made, and they could base their appeal upon the idea that the stipulation wasn't accurate, or that what was agreed upon as to the facts were not entirely accurate. So you let it play out because then whatever objections can be made along the way. But I get it. Doesn't mean I don't sympathize with you, Jim. Doesn't mean it doesn't turn the whole thing into a laborious exercise at times. So thank you so much, Jim, for the question. Thank you, first of all, for putting the Marshall Islands on the map. Add that to the tour, to the World Tour 2026, Tiffany. Marshall Islands, making a stop. The Courtroom Confidential World Tour. All right. Shall we keep it moving? Let's keep it moving.
Hi, everybody. Hi, Courtroom Confidential. Josh, I hope you're feeling better and that you're up to doing the show because we don't like to go Sundays without you because you're just the best and we love you. So my question is general, but I guess you could say Wendi Adelson related. As a prosecutor, when you have enough evidence, do you immediately go to the judge or whoever you have to go to get that arrest warrant? Or do you wait for a specific time? Now, maybe you don't wait. Maybe you go right to the judge immediately. You get that arrest warrant. Do you ever wait to execute the arrest warrant, knowing that you're going to have to get ready for trial? So, do you ever wait? Do you ever know that you can go out and arrest somebody, but you don't because you're waiting? How do you decide to take somebody to trial? Is it a decision, or do you go right to it as soon as you have enough? That is my question. Love you guys so much. Happy New Year.
Sonia calling from Chicago, Illinois. Thank you so much, Sonia. Always love hearing from you, all your support, your help as a mod, everything else. Always great to see your face in the chat. And this is a great question. When is the decision made to execute an arrest? Is it made the second that they feel that they have enough evidence, or do they sometimes wait? And the answer is, the vast majority of the time, it's made when they feel they have enough evidence. But there are instances where they'll be a little patient, where they will hold back and say, can we do a little bit more in investigation before we make an arrest here? Usually those are going to have to do with very serious cases, but also serious cases where they're not worried about the defendant being in the world. There's not an immediate concern for public safety. It could be in cases involving, like kind of complex financial crimes where they want to make sure they've got this all locked down before they go out and make an arrest. If you've got somebody, though, that you feel is a threat to the public and a danger, you're going to go get them right away. And that's why, we talked earlier about investigative grand juries. Many times they have a lot on someone. There are cases right now, I wish I could tell you, but I'm sworn to secrecy, that we consider unsolved crimes that are solved. Police believe they know who did it, but they just want to make sure they get everything done right and every T crossed and I dotted and all their witnesses lined up before they make an arrest and an indictment of someone, because it can be a big, big deal. It might involve a high-profile person or a high-profile victim, and they want to make sure they don't drop the ball on it. So they'll do investigative grand juries, and sometimes these things can take place for years. But in the vast majority of the time, it's when they feel that they have enough evidence. And this gives us a good opportunity to talk about, too, the different ways that a person can be arrested. An arrest requires some sort of probable cause, right? Some sort of evidence that a crime was committed. How do you establish that? Well, it can take place in front of officers. If officers witness a crime taking place, if they arrive on the scene of a liquor store robbery and the crime is taking place in front of them, they have probable cause to arrest right then and there. They don't need to wait for approval from a judge or a DA. They arrest that person, they book them, and then they present the case to the DA's office. DUIs are a perfect example of this. Police are driving, they see somebody swerving, they pull that person over, they administer all sorts of tests, they decide you've been driving under the influence, and they arrest you for DUI. Before a criminal complaint has been filed or you've been indicted. Then they take that case over to a prosecutor, and they have to do that in California within 48 hours. And a prosecutor takes these in custody cases and they go, yeah, file this DUI, file that DUI is a reject, this one, whatever. And then those people show up 48 hours later to court and be formally arraigned and charged with a crime. Or police can go out and do a bunch of investigation on, say, a murder, or a better example probably is a sexual assault. A victim comes forward, says, I was attacked by this person. Here's where this person lives, and this is what happens. And police go out and perhaps gather some forensic evidence, some videotape evidence. Maybe they go out and interview the defendant. Then they present all of that to the DA's office. And the DA says, okay, I think you have enough here. I'm going to go ahead and file an arrest warrant on a criminal complaint. So now you've both filed the criminal complaint with the court, which also then gives the police the authority to go out and make an arrest based upon that warrant. That person brought into court and then arraigned within 48 hours of their arrest. And then the third way is where they don't even involve the DA's office. For whatever reason, the police go straight to a judge and they present their evidence to a judge, and the judge signs a warrant for an arrest. That's called a Ramey warrant. And the DA isn't even really involved in that. They go out based upon the warrant from the judge, they arrest that person, bring them into court, but still the DA's office has to take a look at that evidence and sign off and sign a criminal complaint. At the end of the day, Police are doing the arresting. They're the executive branch, and the prosecution is doing the charging because that's their job as the DA's office. And then all of your speedy trial rights are at play. So that's why they want to make sure that they've got enough. Not just the prosecution's not just looking for probable cause to arrest. They're looking for, do we have enough evidence to prove this beyond a reasonable doubt? Because sometimes things can move quickly. They got 48 hours to arraign them. They got 10 days to take them to prelim, and they've got 60 days to bring them to trial. So if you don't got your case together, if you've got stuff that's outstanding and it might take you 6 months to get, you better think twice about making that arrest, because you could be forced into a situation where you go into trial before you're ready to go. Hope that makes sense, Sonia. Great question. Well, thank you so much for asking. All right. Southern CJB, thank you for the super chat, says, did you all watch the new 2020 on Donna? No, I haven't watched that. I didn't even know about it. Did we know about that, Tiff? We got to go watch that. Thank you for that heads up. We'll go watch that right away. And Fala, damn it, has been a member for 5 months. Everybody says, I love it here. Well, we love having you here. All right. Catch your breath, Ritter. Where are we at here? Before we move on to the next question, we did get a question from Kelly. Kelly, if you're out there, we received your question, but the audio was, we just couldn't hear it. It was too poor. I could kind of hear a little bit of what you were saying. I just want to let some of you know that sometimes you guys ask questions and we just can't hear it, and so we can't play it. So Kelly, please call in again and ask the question again, but let's move it along here.
Hi, yes, this is Kathleen from Cleveland, Tennessee. My question is, if a client is so unruly, and in other words, they're violent, they attack their lawyers or anybody in the courtroom, how do they try them? Do they have to do it by video, or how do they do that? I was just curious, because I saw a case, I think her name was Taylor Schabusiness, and she kept attacking her attorney. So I was just curious of how do they try someone like that? Thank you. And thanks for being a great program to listen to. Okay, bye.
Kathleen from Cleveland, Tennessee. Let's put you on the map. Right outside of, is that what is that? Chattanooga? Right outside of Chattanooga. Great question. Anytime we have an opportunity to talk about Taylor Schabusiness, I'm going to take advantage of that. Look at that. Look at her. Just kind of crazy personified. I'm going to explain to you, for everybody who hasn't had the pleasure of knowing what Taylor Schabusiness was up to, what business Taylor Schabusiness had. But I will warn you a little bit that this can get graphic. She is accused of, oh shoot, I didn't put down his name. She was accused of killing a young man who was her quote unquote romantic partner. There he is. What's his name? I forgot his name. Somebody's putting it in the chat. Kaylin's going to put it in the chat for me. All right. Thank you, Kaylin. Anyhow, when police arrive on the scene, they find that's it, Shad Therion. They find poor Shad's head in a bucket. Thad Therion. No, Shad. Okay, pardon me. Shad Therion. They find his head in a bucket, other body parts, I'm going to put parts in quotes, hidden in other areas. She confessed to strangling him to death during the act of sex, and then continuing to participate in that activity with him even after he had died. and then dismembering him, removing his internal organs. Obviously, they think meth played a role in this whole thing. But since that time, it's not just drugs. She's got whatever you want to call it, severe mental issues. I don't know what, but she's got a violent streak in here that you just don't see all that often. And she's attacked her attorneys many times in court. She has to show up to court now. There she is. There she is. Even handcuffed, by the way. They know she's violent. So she even comes in handcuffed and she still goes after her attorneys. I mean, look at that sheriff's deputy there is not a small dude, and he's really having to deal with her. This is, by the way, upsets me from a law enforcement perspective. They never should have allowed her to kind of sit unshackled to her own chair with her attorney sitting there knowing her violent history. Now she comes wheeled into court. I've dealt with people like this before when I was there. She is. Now they got her wheeled into court. She's shackled to her chair. I've had defendants before like this come in the Hannibal Lecter outfit. Yeah. Spit mask on top of her, wheeled into court. It's a whole ordeal. 4 or 5 deputies escorting them down the hallway. It becomes quite a spectacle. And that's the way they handle it. Kathleen, your question is, how do they handle it? That's how they handle it. Because in spite of all of that, they're not going to deny this person their constitutional rights. So they're going to get their court. They're going to get their trial. They're going to get to come to court every single day, even if that means that they're shackled and wearing a spit mask and treated like an absolute child every single day. They're going to bring them in, and they're going to put on the witnesses, and they're going to put on an opening statement, and they're going to pick a jury, and they're going to make their arguments, and they're going to cross-examine people, and they're going to have their entire trial with them sitting there like a child until they get through the whole thing, because it doesn't matter. It doesn't matter how you want to behave. You still are going to get your constitutional rights, whether we have to force them upon you or not. Best Nancy says, how do you deal with a person like that? I don't think that's fixable. I don't know what kind of med she's on. I don't know if there is a way to fixing that. I don't know. I don't even know what's wrong with this person. Is it mental disorder, or are they just bad? I don't know. But great question, Kathleen from Cleveland, Tennessee. Thank you so much for asking. Like I said, anytime we can have a little Taylor Schabusiness to talk about, happy to do it. All right. Oh my Tosh, thank you so much for supporting the mods with coffees. Appreciate you, oh my Tosh. Pammy MC has been a member for 16 months. Love the entire CC crew, mods, Josh, and Tiff, and Kaylin. Thank you so much, Pammy. We love you right back. Michelle LA67 has been a member for 4 months, has always learned so much from Josh and crew. Thank you. Well, thank you so much for coming back. All right, let's keep it rolling here. Where are we headed to next?
Hi, Josh. Hi, mods. Hi, CC crew. It's Little Miss Red Velvet from Manchester here. Now, I'm not sure if I've sent questions in before or not, because with Christmas and New Year, I'm not quite sure where I am. And this one is about the Charlie Kirk case and Tyler Robinson case. And the defense are saying there's a conflict of interest with one of the prosecution lawyers, as their child was present at the rally. They were 85 feet from Charlie Kirk, and they have texted with the parent about the subject. My question is this a conflict of interest? And should this prosecutor be removed from the case? Look forward to seeing you on Sunday Fun Day. Speak to you later. Bye.
LMRV from Manchester, England. Always love hearing from you. Thank you so much for asking the question. This is an issue that came up recently. They filed a motion on this in the Charlie Kirk case. The representatives for Tyler Robinson. This is Oh, I'm blanking on her name. I'm really putting Kaylin to work today. What is the name of the lawyers that are now assigned to Tyler Robinson? Kathy Nestor. See that? I just thought of that myself. I'm not being fed this information at all. Kathy Nestor, who actually also represents Kouri Richins, is now representing Tyler Robinson. She's a very experienced, qualified attorney. And she's pulling out all the stops and trying everything that they can. Here's what I'll say on this. I am all for defense attorneys filing whatever they feel is necessary to zealously advocate on behalf of their clients. All for that. I don't think that there should ever be a concern about wasted paper or wasted court time when you have an argument to make. The big thing there being when you have an argument to make. And some of these arguments, I feel, are a little bit of spinning wheels here. Now, I'm going to give Kathy a little bit of leeway because this is a death penalty case. And so when it comes to a death penalty case, it's kind of that idea of no stone left unturned because you never know what might create an appealable issue. And many times people, defense attorneys in these situations don't even view it as a matter of winning or losing as much as it's a matter of saving their client's life. And so they're going to make every possible argument. They're going to file every possible motion, knowing they're probably going to lose, but every time they do, every time they make an objection, every time they make an argument, every time they file a motion, all of that creates an appealable issue that who knows how some appellate court years and years and years down the line might view it. So is there a conflict of interest here? I think clearly no. Clearly no. The argument is that someone of the hundreds of people who happened to be in attendance on the day that Charlie Kirk was assassinated, one of those people has some sort of loose association with the prosecutors. I don't even think the person who was there is the person who has the relationship. I think it was somebody there was speaking to someone who has then a relationship with the prosecutor's office. In other words, I think it's even a further degree removed from the prosecutors. But I'll tell you this, even if a close person in close relationship with one of the prosecutors was in attendance that day, I still don't feel that that's some sort of disqualifying relationship. They're not going to call, look at all the people there in attendance. They're not going to call those hundreds and hundreds of people as witnesses. Are those people witnesses to a crime? Yes, they are. But they're not on the witness list, and they're not going to be witnesses to the case. And just because they happen to be in attendance to something that, by the way, any one of us, unfortunately, can watch online now, doesn't somehow disqualify you or make the prosecutor's office certainly somehow disqualified from prosecuting the case. So it's a very tenuated, weak argument to begin with. But like I said, buckle up. They're going to make every possible argument that they can in this case, unabashedly so, because they feel that they're trying to save their client's life. And so, you know, I don't think they think this is really going anywhere. I don't think the judge thinks it's going anywhere, but the judge is going to issue a ruling, and that's all they want is an issued ruling so that they have something to appeal later on. Thank you so much, LMRV from Manchester, England. Appreciate you. Always love hearing from you. All right, let's keep it rolling here.
Hi there. I'm a brand new listener and pretty new to LawTube as a whole. So I should preface this by saying that I'm pretty much queen of dumb questions, although I'm calling because I have learned even just through this community that you guys are so gracious and have taught me so much in the last year or so. So I thought I'd just try calling in. My question today is about being a defense attorney. And I do want to say that I know that they have a bad reputation sometimes in the general public, and I'm not one of those. I have utmost respect. I think that the defense attorneys are crucial to protecting the people, and also even making sure we get the criminals. They have to have their due process so that we convict the right guy, at least most of the time. But I am curious about what you think when it comes to knowing someone probably did what they're accused of, and you're trying to get them off, or even just a lighter sentence, and they could be a danger to society. Does that ever mess with moral or ethical convictions? Not even just from a legal standpoint, but from a personal standpoint. I would love to hear your thoughts on it if you get this message. Thank you so much.
Nell, thank you so much. Thank you for being a new law tuber. Thank you so much for being a first-time caller. Thank you so much for being a part of our community. And I love this question. I get this question every so often. Some version of it. How do you defend those people? How do you sleep at night? How do you represent somebody that you know is guilty? Nell even adds a little extra sprinkle to it by saying, how do you handle knowing someone might possibly be a danger to society? How do you represent somebody like this? Well, I'll say for myself personally, I have the privilege of being in a position where I don't have to accept every single case that walks through my door. If there is a person who needs representation and I just feel like it's not a good fit for me, I can say no. I can say I don't feel good about this one. I don't want to play in this sandpit. I don't want to deal with this one. And I've done that before. Cases that are just not something that I feel that I can get behind fully. And that really is the question. For a defense attorney, it's a tough job because you have to not hold back. You have to. Your job is to. The Constitution requires of you to defend someone as zealously as you can. Now, you have to follow the rules. You have to follow the law. You're not supposed to try a bunch of dirty tricks, but you have to, if there are legal issues and arguments at play, you have to pursue every one of those zealously. Zealously. Think about that. With enthusiasm, not just limping into court, not just half-heartedly making the arguments, but zealously advocating on behalf of your client, even if you feel that that person did something horrific and might be a danger to society. So one, you have to be comfortable with doing that. And if you're not, then you should say so. Now, what do lawyers in a position where there is that conflict, how do they handle that? I will tell you, it's a struggle. I've talked to other lawyers who've represented people who they feel are bad folks. And it is difficult. And that's why I feel like instead of being criticized, there should be a little more empathy and understanding for what that lawyer might be going through. Again, if somebody's doing dirty tricks, I'm all against that. If somebody's trying to twist the law and find, inappropriate loopholes, I'm not talking about that. I'm talking about a person who has to stand up next to a person that might be a bad person and advocate on their behalf. That is not easy. And I'm sure they're not this is not a great day for them. A lot of times too, think about public defenders. They're not even getting paid the big bucks to do it, right? It's not like they can say, oh, well, hey, the paycheck's good. They're doing this just because they're basing it upon what they feel is the right way for justice to be handed out. And that is when both sides are zealously advocating, the truth will come out. So great call. Great question now from Michigan. And I'm so glad that you are a new member to our community. And I'm so glad that you asked this question. And the answer is, it ain't easy sometimes. And I applaud those people who are willing to do it. Sometimes I don't and I applaud those people who are also willing to admit when they can't do it. And sometimes I'm of that group as well. All right. Thank you so much. Are we having fun, by the way? Are we enjoying this? I hope that we are. What have we talked about today? Tyler Robinson, Taylor Schabusiness, O.J. Simpson, Shanna Gardner, Kouri Richins. We've been all over the world, including the Marshall Islands. All right. Fueling up the jet. Ann Potter, thank you so much for grabbing some coffee for the mods. Appreciate you. Where are we off to next here?
Good evening, Josh, Tiff, Kaylin, and CC crew, and mods. Can't forget the mods, of course. This is Helen Scottish Lama from a Baltic, Edinburgh. My question is related to, in part, to both the Melody Buzzard and Nick Reiner cases, but in that they are both most likely going to be sent for competency evaluations. But my question is more around the other groups who may not be competent to stand trial. So those with autism, learning disabilities, intellectual disabilities, other neurodevelopmental disorders, those who are starting at the other end of life who are starting to show signs of cognitive impairment, and obviously children. What sort of procedures are there so that the courts can actually make sure they understand and can actually help in their own defense, especially in things like when it comes to trial? Thank you.
Helen, the Scottish Llama, calling from Edinburgh, Scotland. Let's put you on the map. Thank you so much for calling in again. Always great to hear from you. Great question, too. Talking about Ashlee, Buzzard, Nick Reiner. A lot of cases that seem to be coming up recently where this issue of insanity as a defense may be at play. But even before we get to that, competency. So just a quick reminder, there's two issues at play here, two concepts. One is insanity for the purposes of not guilty by reason of insanity, and the other is competency. And one, those are asking questions about a person's mental condition at different times. Insanity asks about what was the person's mental state at the time of the crime. Competency asks about their mental state presently as they sit in court. Insanity asks the question of, can the person appreciate the consequences of their actions, which is one very specific question, whereas competency asks, do they understand the nature of the proceedings and can they assist in their own defense? And Helen's question has to do with, well, even when we're not dealing with somebody who's mentally ill or, has some sort of mental or, injury that causes them to not be able to appreciate what they've done or their, might affect their competency. What about people who are just dealing with things like autism or other mental struggles that might affect their competency? The answer is everybody's kind of treated the same way because the question remains the same as far as the law is concerned. And that is a very low threshold, but can they appreciate what's going on, essentially? In other words, we don't want a system where people who just don't know what's happening are being tried for murder, right? So what you're going to find, and I imagine this is going to play out in both the Nick Reiner and Ashlee Buzzard cases, is the following process. First of all, someone has to declare a doubt as to the defendant's competency. They cannot do it themselves. They cannot go into court and go, Your Honor, I'm not competent. So usually that's the attorney will declare a doubt. as to their competency. Nick Reiner is going to be in court on Wednesday, the 7th. My guess is that we might be hearing from Alan Jackson that day, declaring a doubt as to his competency. Now what happens? Well, for all criminal proceedings are paused at that point while a evaluation is done of that person's competency. In California, it's pursuant to Penal Code Section 1368. So what you might sometimes hear an attorney say in court, so that they're all speaking in lawyer code talk and not entirely, bringing up to the public that they're questioning their client's competency, is they will say, Your Honor, I would like a 1368 evaluation done of my client. And then they are sent to, or the other thing they might ask for is, Your Honor, I would like my client evaluated in Department 95. That's another code speak here in Los Angeles. Department 95 is the competency court where somebody's proceedings are sent to so that they can be evaluated. Another fun fact is Department 95 is affectionately referred to as the pickle factory in Los Angeles because it is in a building that in fact used to be a pickle factory. So sometimes you'll hear, oh, where is that defendant now? Oh, they're out at the pickle factory. It's not derogatory. It's just kind of a insider knowledge name of what they call Department 95, where somebody is going for a competency evaluation. They will undergo evaluations by experts specifically tasked with determining someone's competency, not whether or not, yes, that can include that person's schizophrenic, that person suffers from whatever kind of mental illness or defect. But in spite of all of that, are they still competent? Which again is a very low question. Those evaluations are then sent back to the court and they'll have an entire hearing on this for the judge to decide, does it reach that legal threshold? So there's a medical psychological evaluation, but it's a legal question of, can they appreciate what's going on? And I know that the last time we saw him in court, he was in a suicide prevention vest. I know that we've heard about all sorts of mental issues that he has at play. The question is going to be, does he know who his attorney is? Does he know who the judge is? Does he know what he's charged with? A very low standard. So thank you, Helen, from Helen, the Scottish Llama from Edinburgh, Scotland, for asking that question. Something that I'm sure we're all going to be talking about for quite a bit. Court Dog Daniel, thank you so much, says, sometimes I need a Department 95. I think sometimes we all need a visit to the pickle factory. All right. Julie Ann Holden, thank you so much for buying the mods coffees, keeping those mods awake this morning. And Ms. H1071 says, I appreciate you, Josh. I'm a budding paralegal and your help explaining everything so clearly. Oh, wow. Love to hear that. Thank you so much. I appreciate that. Josh, you're one of the lawyers. This is Steph's 2 times pause up. You're one of the lawyers that have helped me decide that I want to be a paralegal. Oh, I love this. Going to get my paralegal certificate to help those attorneys and because I love learning about the law. Oh, look at this. Changing professional callings all along the way. All right. Oh boy. All right. Don't get upset, but we're down to the final 3 questions of the day. But we've had a pretty good day, so no getting upset about it. But here are our final 3 to bring us home for this edition, the first 2026 Sunday Funday.
Hi, Attorney Ritter. This is Court Dog Daniel from New Britain, Connecticut. With the hearing coming up this week, I have a question about the Raul Valle case in Milford, Connecticut, which is basically right in my backyard. It stems from a high school stabbing involving 4 students where 1 student died. Valle was a juvenile at the time, but he was tried as an adult. The jury acquitted him on the top charges and hung on the lesser counts, including reckless manslaughter. With the hearing this week, what's the most likely path now, retrial or plea? And because he was a juvenile at the time, would you approach the strategy or plea posture differently? And also, if you were defense counsel after that partial acquittal, would you ever advise taking a plea with any jail time, or do you push for a second trial? Thanks. Happy New Year.
Daniel, Court Dog Daniel, we just saw you. I know you're in the chat. Thank you so much. One of my dudes calling in from New Britain, Connecticut. Appreciate you, my friend. Yeah, the Raul, I say Valle. Am I saying it wrong? Is it Valle? Valle? I don't know. I say Valle because it's my Southern California Espanol roots playing a role in how I pronounce that. But he is accused of the murder. Originally, he was accused of the murder of Jimmy McGrath, who was 17 years old when he lost his life. This is a really horrible case. I mean, they're all horrible, but this one is just so unnecessarily horrible. This was a Connecticut house party, a bunch of stupid high school kids thinking they're tough. That's what bothers me about it. So apparently, you know, we didn't follow this one super close. It was a trial that was, I think Court TV had it, gavel to gavel. A lot of people followed it. And it had a conclusion to it that has a lot of people scratching their heads. So anyhow, the short version is a fist fight breaks out over beer. So stupid. That fight leads to Valle and his buddies kind of coming together and deciding they need to go back and finish that fight. At one point, there's the idea that he asks for a knife. There was a knife in the whoever was driving's car. They go back. Another fist fight breaks out. This time, Valle is armed with a knife. He stabs more than one person, but ends up killing Jimmy McGrath. Just like I said, stupid kids acting tough, and some young man, not even a full-fledged adult, loses his life. It's horrible. But the jurors felt that this wasn't murder. They felt that it was much more along the lines of a manslaughter, but they couldn't even agree on that. So he's acquitted of murder. So this is interesting. He was charged with murder. The judge added the lesser includeds, not originally charged by the prosecution. But he's acquitted of the murder, meaning they can't retry him on that. That is a verdict. He won an acquittal on murder. But because they were asked the question about the lesser includeds, now they can retry him on the lesser includeds, including aggravated manslaughter, which is still could land him in prison for the better part of his life. Right now, what's happening procedurally is he's waiting to get a new lawyer. Last time he appeared in court, his lawyer from the previous trial is no longer representing him. He wanted more time to get a lawyer. He's coming back, I think, this week for the judge to decide. You know, the judge told him, show up with a new lawyer or I'm appointing you the public defender. But it does look like this thing is heading back to trial. Now, your question, Court Dog, is what would I do about trying to get a plea? I imagine they've been looking for a plea deal all along the way here. And is his attorneys in a better position now that he's got the acquittal on the murder? Sure. I think that gives them a little bit more leverage, but I also think the prosecution is probably pretty dug in on this one. And they're thinking, no, he can plead to manslaughter and he can go to prison for 10, 20 years, whatever it is, the exposure is on that. But we charge this man with murder. We feel he's good for murder. Now, he got lucky and got off on an acquittal, but I don't think they're going to deal this thing. I don't think they're going to arrive at some sort of plea deal that will give Raul a reason to plead and not take his chances at trial, I guess is what I'm saying. For a young person, they probably feel like I might as well take my chances. Unless they can offer him something that he feels like, you know what, I can put it behind me. I do a few years in prison. I move on with my life. I see this thing going back to trial. And I understand too that the parents, the family members of the victim who lost his life are very upset. And so there's probably a lot of pressure coming from them as well. Great question, Daniel, otherwise known as the court dog. Appreciate you asking. Lee Hilliard, thank you for the super chat. Says, love your channel, Josh. Tauberbisch of Schiem, Germany. Hope I got that right. Thank you so much. And then thank you to Ann Potter for buying the mods coffees. Appreciate you, Ann. Oh my Tosh has been a member for 1 month, everybody. Says, I believe Nick Reiner's case will end with him taking a plea after he's deemed competent. I'm probably wrong, but that's what I think. I get it. I think it's probably going to go to trial because I don't think that the prosecution is going to back off of murder on this case with special circumstances, meaning he's looking at life without parole. And usually when somebody's looking at life without parole, they think to themselves, I might as well take my chances and see what happens. Roll the dice, as they say. Karen G7201, thank you so much for the super chat, says, Latina here, you're pronouncing it right. Thank you so much. Thank you so much, Karen, for the official comment from the Latina community. All right, let's keep it rolling. Oh, boy. Don't yell at me, Kaylin. I'm hitting all the buttons I can.
Happy 2026 and happy Sunday Fundy, Joshua, Tiffany, Kaylin, Maud, CC family and guests, Alicia K. Mayo, Humboldt, Tennessee. Joshua, can you explain the lawsuit that was filed against Will Smith? One place I read one thing, another place I hear something else. So can you make it make sense? Appreciate you. Can't wait to hear what you got to say. Happy Sunday Fundy, y'all. Bye.
AKM from Humboldt, Tennessee. Let's put you on the map. It wouldn't be a Sunday without you. Poor Will Smith. This guy is on his, this is supposed to be his kind of image rehabilitation tour, right? This guy cannot win. I don't know if I feel all that bad for Will Smith. I mean, you smack a person upside their head in front of the entire world. You should probably, hang out in a cave for a little period of time, but not Will. Will's back on tour. He's trying to make a comeback. He's trying to resurrect his reputation. Talk about a guy too that could, like, everything he touched was gold. I mean, didn't he receive the Oscar for Best Actor that very same evening? Was it Best Actor or Best Supporting? Like, I think he got an Oscar that same evening. It's just remarkable to me. And then now, what has he been banned for, like 10 years from the Oscars or something? I don't know. Send him to the pickle factory. He definitely needs a visit to the pickle factory. Anyhow, he's on tour. Well, he can't even avoid trouble while he's on tour because this latest lawsuit, this is a wrongful termination lawsuit with a sexual harassment twist. I'm not even quite sure, Alicia K. Mayo, I understand the whole story, but here's what's happening. A gentleman by the name of Brian King Joseph, who is a violinist who plays this rocking out electric violin, was on tour with Will Smith. He is saying, according to the allegations, that he, at one point on the tour, he goes back to his hotel room and there's a note left for him. Someone had been in his hotel room. It was obvious to him. And there was a note left for him, apparently inviting him to participate in some sort of sexual encounter, is my most diplomatic way of putting it. There's a handwritten note saying, Brian, I'll be back, just us, with a heart signed Stone F, whoever Stone F is. The room also had like beer bottle, baby wipes, a backpack, HIV medication in another person's name, a bunch of stuff inside his room that didn't belong there. He is saying, Brian King Joseph, that when he received this, he reported it to the tour manager saying, somebody's been in my room. This is all bad. What's going on here? What are you guys going to do about this? He's saying that shortly after that, he was excused from the tour. So he's saying I was wrongfully terminated in retaliation for me reporting this apparent sexual harassment. I don't believe that the lawsuit names Will Smith, but it's Will Smith's tour. Okay. And I think there's kind of all wrapped up in this, the assumption that it may have been Will Smith who had left him the note. Any way you look at it, not a good look for Will Smith. And certainly from a PR perspective, not a good look for Will Smith. What's going to come of it? Who knows? These things usually end in some sort of out-of-court settlement. They'll probably write a big check to Brian King Joseph, and he can buy himself another fancy violin. But I don't know if this thing's ever going to see the light of day inside of a courtroom. But thank you for that, AKM. All right, everybody. Get out your hankies. It's the last question of the day, but we've had a good one. This was a best hopes for kicking off 2026 with a Sunday Fun Day. Our last question actually comes from a viewer who I'm just going to say was presented with difficulties in leaving us a message. So we decided to go ahead and make an exception for Debbie from Phoenix City, Alabama. We're going to go ahead and put you on the map there. Asking about Nick Reiner. And this is Debbie's question. Since they are reporting that Nick has schizophrenia that could have been caused by drug addiction, will they let his body detox, then see how he reacts without drugs in him? If his alleged schizophrenia was caused by mental health, it should reflect. I think what Debbie is saying is, are they going to figure out that his mental issues are caused from drug abuse or from actual mental illness? What if he's not really schizophrenic and those drugs are now given to him in a detox body would be harmful as well? So in other words, are they going to try to decipher the difference? Oh, Debbie's here. Thank you so much, Debbie, for the question. Are they going to try to determine, is his mental health issues drug-induced, or is it actually from some sort of, a diagnosed schizophrenia, which is a mental disease not entirely tied to narcotics abuse? And the answer is yes. They're going to try to get to the bottom of all of this. I mean, something to keep in mind, guys, is you can't play games with this stuff. This isn't like their first trip around the block for prosecutors when it comes to people making mental health defenses, okay? You can't come into court and say, hey, I was all messed up in the head and I can't remember and I don't know what I did. Therefore, send me to the pickle factory. Don't send me to prison. Not how it works. It's going to become a battle of the experts, but there's going to have to be experts that say not just he was suffering from mental health issues either caused by substance abuse or mental health issues caused by schizophrenia or whatever else they want to say. All of that. And you can still be convicted for murder. They're going to have to say, because of all of that, he could simply not appreciate the consequences of his actions at the time. I will say, just to kind of cut this off before it begins too, I know there's been a lot of talk about him saying, I can't remember anything. I can't remember what I did. I don't know what I did. Doesn't matter, dude. If what you were doing at that time shows evidence that you could appreciate the consequences of your actions, that is still murder. Somebody who flees the scene of the crime, goes to a hotel room and washes himself up from all of the blood having slaughtered his two parents, to me, that's somebody who knows what they did is wrong. And that is the arguments that the prosecution is going to make. The defense is going to say, no, he didn't. He didn't know what he was doing. He was in this either drug-induced or schizophrenia-induced coma and had no idea what he was up to or could appreciate the consequences of his actions. Last thing I'll say on all of this is jurors, in my experience, do not like these types of defenses. They don't like somebody who sneaks into their parents' bedroom in the middle of the night and slits both of their throats with a knife and then says, hey, I've got problems. I didn't know what I was up to. They just don't take kindly to those types of defenses. But we will see. This one's going to play out for quite a bit of time, and he will be in court on Wednesday. All right, guys. You all are fantastic. True Crime in a Minute. I know you. Thank you so much for the super chat. Was trying to gift memberships, but on my iPhone and need computer to do that. Happy New Year to the best. Thank you for the whole crew of Phoenix City, Alabama is near my alma mater, Auburn War Eagle. Okay, sounds good. Thank you so much. True Crime in a Minute for the super chat and for the kind words, and Happy New Year right back at you. I know iPhone does not make it easy. All right, I got some announcements for you. First of all, I got a website I want you all to check out. It's called thecourtroomconfidential.com. You will find the 3 M's. 1, messages. If you would like to leave a message so that your question can be answered at the next Sunday Fun Day, go to thecourtroomconfidential.com and click on Leave Us a Message. Number 2, membership. If you want to become a member of thecourtroomconfidential.com, we would love to have you as a member. So please join the crew by clicking on Become a Member, and you can find out about all the perks and benefits of that. 3, merch. Do you like this shirt I'm wearing? Do you like the color? I think I got somehow a little bit of a spot on here. I thought this was going to dry off, but I might need to have this one cleaned. I love this color. This is one of our new colors that we have. We have plenty of these available. What is this one called? No guesses? Shirt color, Dayquil Dust. Yeah. I need to get like one of those steam things to just kind of clear me up. Therapist, says emotionally available salmon. Very good. Afton says rebuttal red. Also very clever. One more. Lee Hillard says stonewashed rose. Appreciate that. If you like this color. Alicia K. Mayo says she's a brick courthouse. Clever. Cute. If you like this color, we've got plenty more available, along with brand new sweaters, t-shirts, coffee, because murder is wrong, which is a true statement that you can wear around town. Plus mugs, plus pajama pants, everything else that you guys would possibly want, we've got available at the shop. So please go check it out. What did you miss? Well, you missed a few things. We've got some good stuff up for you. First of all, I don't think you're going to find this anywhere else on YouTube. We did a top 10 trials to look forward to in 2026. Please check it out. It's getting a lot of attention online. We're very happy with the discussion that we had, and there's a lot to look forward to in 2026. So please check that out. It's available on our channel right now. Also, we did a special case files episode on the Barry Morphew case, the murder of Suzanne Morphew. We put a lot of work into this one. We had help from Karen McDonough from the interview room, along with everybody's favorite, Gisla from Grizzly True Crime, helped weigh in, and Kaylin knocked it out of the park on this one. Really, really great work. We're very proud of this, so please check that out. And finally, if you are a member or a subscriber to Fox Nation, please check out the latest episode of the weekly rap sheet, which is up right now on Fox Nation. Something I'm very proud to be a part of, along with Paul Morrow and Donna Rotuno. Please go check that out. Stay tuned for this week. We will be following the Sarah Grace Patrick trial. I believe jury selection is expected to begin tomorrow. So we're not going to follow that, but as soon as opening statements start, we will be following that on our sister channel, Courtroom Confidential Live Trials. Please check it out. We would love to have you in the chat. Monday, we have a very special guest joining us live at 5 p.m. Pacific, 8 p.m. Eastern. That is tomorrow night, back here on the channel for our weekly True Crime Docket, and that is going to be Derek Levasseur. And we're going to be talking about Nick Reiner. Is he insane? Is it insanity? Are any of us insane? Please check that out. Tomorrow, Derek Levasseur, right here at 5 p.m. Pacific, 8 p.m. Eastern. He's our first guest of the new year, and we're very proud to have snagged him. Then on Tuesday, I will be on Professor Joe's channel called Professor Joe Explains. I don't have a thumbnail yet for that one, but please check that out live at 2 p.m. Pacific, 5 p.m. Eastern on Tuesday. And then because Ritter's getting on a plane again, we got to move things around. So we're not doing our Wednesday night live. We're doing it Thursday night. So live Thursday at 3 p.m. Pacific, 6 p.m. Eastern, we will have an episode. So we're just switching it from Wednesday to Thursday, changing the time around a little bit just to keep you all on your toes. A lot coming up. Big year ahead, big week ahead. We're so glad to have you all as a part of our crew. And thank you so much for all of your support. Thank you, everybody who showed up this morning. Thank you. Happy New Year, everybody. It's a great way to kick off the new year. Please follow us on Facebook, X, and Instagram. Big thank you to our mods, Afton, Sonia, Kathy, and therapists Kaylin, you're the best. Couldn't do it without you. And Tiffany, you're the best thing that ever happened to me. Thank you guys so much. Have a great Sunday. Talk to you all soon. Take care. Bye-bye.